Be ready. 5 seconds to go. Start. Therefore, our agreement not to reduce the water supply no longer held good. We resumed our freedom of action. We were ready to talk when they or Pakistan wanted because we did not intend to shut the door to agreement. But the talks had ended and our delegation would be returning home. The bank people told us, however, that Pakistan's attitude was changing and that they were saying that they accepted the principle. Since there were chances that a way out would be found, the bank asked our delegation to wait for a few days more. Our representatives agreed to do so. The point is that our former agreement with the World Bank or with Pakistan for not reducing the supply of waters has ended. We have every right to reduce it, but we do not want to stand on legal rights in this matter. We want to do something which would harm neither Pakistan nor us. Therefore, we again told them that we would do nothing in haste which may harm the landowners and peasants in Pakistan. We would give them a chance to make their own arrangements. After all, we had to reduce the supply of waters, but we would do it having regard to the conditions. That is, we still stood by the principles which we accepted in the agreement of 1948. If you have read the Pakistan newspapers, you will see that there is a great storm and outcry as if something is going to take place on July 8 here in Nangal, which would immediately stop the waters flowing into Pakistan and create a drought as a result of which lakhs and crores of people would die of hunger and thirst. This is wrong and deplorable. We cannot tolerate it. We have told Pakistan clearly, time and again, that for the present we would not reduce the supply of water. It is a fact that they have built one or two canals from which they can take some water. Therefore, they can take water from their side and we would reduce supplies to that extent. This would not reduce their total supply of water. If they could build some more canals as they intend, then this process would go on. The exploratory talks held under the auspices of the World Bank made it clear that there is no dearth of water. Honorable Speaker, Sir, I am thankful to you for the opportunity that has been offered to me to speak on this small amendment bill. Sir, when this Parliament discussed the 42nd Amendment, it was said that the legislative competence of the Parliament cannot be questioned in the court of law. This triggered the controversy. Ultimately, it was settled down later by virtue of the 44th Amendment. The legislative capacity of Parliament could not have been questioned in those days. Now, Parliament's capacity of legislation has become a mockery through this bill. I do not know how this bill was drafted without giving any due care for the legislative competency of this Parliament. Ever since this government came into power, Parliament is being misused. Most of the laws under state subject were brought here for amendment, encroaching the state power. Ultimately, the state autonomy and cooperative federalism became a laughing stock. It is a small bill, but I am not able to understand the way nationalism was set up everywhere, even in the Advocates Act. The Honorable Minister talks about colonial rule. In 1879, the provision was there. You want to repeat it, but by way of repealing it, you are introducing the same section in the new law. What does it mean? Is it not the same colonial law? I am not able to understand the rationality of the government behind this amendment. What happened to Article 356? Article 356 says that a state government can be dismissed on the recommendation of the governor or otherwise. The word otherwise was used by the president when the Tamil Nadu government was dismissed without the governor's recommendation. It is such a dangerous provision for Advocates Act. You are putting the same word otherwise here. Nobody can say how it is going to be used or misused. This House may many times discuss corruption at length. The Prevention of Corruption Act has been periodically amended, which says that not only the receiver but the giver of the money is also a culprit under the Act and he has to be convicted. The tort is going to be eliminated and given imprisonment or penalty. Does it not mean that the person who is giving money is also liable to punishment? What type of justice are you rendering to A and B between whom the money is exchanged? So, the very purpose of the Prevention of Corruption Act itself is defeated here by the way in which the bill is drafted. For the first time, I have come across a bill which has been submitted to Parliament in which the objects and regions were not at all given. For what purpose are you going to introduce this amendment? I want to know whether the Bar Council of India is going to be consulted when a person is going to be listed as a tout. What will be the role of the Bar Council? Sir, former Chief Justice of India, Justice Bharuch, a decade ago said in the open meeting on the eve of his retirement that 20% of the judiciary has become corrupt. He made an open statement. If a litigant is having a case in a particular court, how will he know that the judge comes under that 20% or the remaining 80%? So, you want to keep the entire judicial system clean, but for a small matter, you are not able to draft a clear law to serve the purpose. What type of purpose is it going to serve? Ignorance of law is not an excuse. That is a legal maxim.